Updating you now on the Aaron Hernandez murder investigation. Today, Hernandez was indicted for the murder of Odin Lloyd. Let's get a closer look now at legal analysis with Michael Coyne, NECN legal analyst and associate dean of the Mass School of Law. Hi, Michael.
Hi. Michael, thanks for joining us. I guess first and foremost, you know, the prosecution called the defense called the prosecution's case weak and circumstantial. They do not have a murder weapon. How much does that hurt them in this case?
People are convicted all the times without murder weapons, but you really have to take a step back and think about the evidence. There were 4 people there that night. One is dead, one is in jail on murder charges, and the other 2 really face very, very insignificant charges, all things considered. They don't look like choir boys. My guess is Mr. Hernandez's defense is going to start to focus on those 2 through cross-examination and the development of their backgrounds. My guess is we're going to find that they may be able to start to try and create some reasonable doubt and also move the public off the perception that it was only Hernandez who was the significant participant here. Those 2 have every reason in the world to put the gun in someone else's hand.
All right, he was already charged with first-degree murder. Now he's been indicted for first-degree murder. Practically, what does that mean for Aaron Hernandez and people understanding this case, and is it a tougher case against him?
No, it's a technical requirement. The district court would have had to hold a probable cause hearing, and if there was probable cause, they could have sent it on to Superior Court. What the government chose to do is skip that stage, have him indicted by a grand jury, and then have the charges now heard in Superior Court. What it does is it avoids the cross-examination of those witnesses and the presentation of that evidence in the district court, and instead allows the government to have done that in secret at the grand jury, making it harder for the public and the media to get access to that information. His lawyers at some point will get access to the information, though.
So almost saving the best stuff for trial.
Save the best stuff for last.
Yeah, interesting.
And as far as where this goes next, all right, where does it go next? And I know we have to have an arraignment, but where's this all playing out?
There'll be a pretrial conference at some point in the near future. At some point, then we'll also look at potentially dispositive motions, motions to suppress. There may be evidence that the defense feels was obtained improperly. There may be statements that they want to suppress from other parties. So we'll be looking at suppression motions, and we'll be looking at framing the case and getting it ready for trial.
You talked about chinks in the armor for the prosecution. What are their strong points here?
Oh, they've got a very strong case based on what we have heard, but from the government to date. And that's what Mr. Hernandez's lawyer was pointing out today, is we've heard one side, and really only one side. We don't know how admissible this evidence is. We don't know how much of it is based on hearsay, how much of it is based on rumor, and how much of it will actually stand up to the test of cross-examination. And that's why a lot of us have written him off and said, wow, it's a very powerful case. But none of us really have seen the entirety of the evidence and understand where the weak parts of this case may be. His lawyers will start to focus in on that, and we may have a much more triable case than at least at first blush it seems.
Interesting. All right, Michael Coyne, thank you so much for joining us.
Thanks, Ellie.